Hi there, I'm Professor Blackmore, and I want to welcome you to ProfessorBlackmore.com, where our goal is to empower results through real productivity. And before I go any further, I want to ask that you please subscribe to my YouTube channel and click the bell so you'll be notified whenever I post new videos. And please also follow me on TikTok and Instagram. Well, today I want to talk to you about the breaking news developments surrounding the Kyle Rittenhouse trial. And I want to jump in and out in a hopefully easy way to understand some of these developments. And I just want to say right off the bat that the prosecution was caught flat-footed, in my opinion, when Kyle Rittenhouse decided to take the stand and testify in his own defense. Clearly, in my opinion, the prosecution was not prepared to cross-examine Rittenhouse because they just did not expect him to take the stand. And it was very risky for the defense to take on such a tall feat for such a young defendant. And I would never put a defendant on the stand, especially someone so young. But in my opinion, this kid made a fool out of the prosecution, and he held up pretty well. And throughout my time with you today, I'm going to take you inside of my notebook and show you how I teach law students how to analyze facts against the elements of the law. Now, I'm only going to look at the two most serious charges. But before I do that, I want to say quickly that my remarks won't relate to the charge count 4, which was the attempted first-degree intentional homicide regarding Gage Grosskreutz. You'll remember that Mr. Grosskreutz admitted that Rittenhouse did not raise his firearm to shoot him until Grosskreutz first pointed his firearm at Rittenhouse. And so any self-defense, affirmative pleading on the part of Rittenhouse as it relates to this count would not be dispositive in any way to any self-defense assertion that relates to the two counts that I'll be discussing regarding the two other individuals who are deceased. And I want to take a side-by-side look as they are alleged in the criminal complaint. Now, the most serious crime, in my opinion, is listed as count 3 in the criminal complaint, first-degree intentional homicide. And when we look at the Wisconsin law, it reads as follows: except as provided in subdivision 2, whoever causes the death of another human being with intent to kill that person or another is guilty of a Class A felony. And then the law also establishes that when the existence of an affirmative defense under subdivision 2 has been placed in issue by the trial evidence, the state must prove beyond a reasonable doubt that the facts constituting the defense did not exist in order to sustain a finding of guilt under subdivision 1. So once self-defense is established, you can't really get to the elements of the main count until you establish that there was no self-defense. So it seems that the Rittenhouse team felt that it needed to prove up these facts by actually putting Kyle Rittenhouse on the stand. So when we look at the law for this side by side with the count as it is alleged in the criminal complaint, this is the count that deals with the deceased individual, Anthony Huber. And when we look at count 1, as it is alleged in the criminal complaint, this is the count that deals with the other deceased individual, Joseph Rosenbaum. So you see some important words when you read the elements of the law, and those important words are intent to kill. And although it was clear to me that the prosecution was caught flat-footed and they were not prepared to cross-examine Kyle Rittenhouse, the entire theory of the prosecution's case was that Kyle Rittenhouse went to the protest event with the express intent of using the gun in his possession to kill people. And I thought that Kyle Rittenhouse absolutely demolished the prosecution's attempts to try to get him to admit this.
Everybody that you shot at that night, you intended to kill, correct?
I didn't intend to kill them. I intended to stop the people who were attacking me.
By killing them.
I did what I had to do to stop the person who was attacking me.
By killing them.
2 of them passed away, but I stopped the threat from attacking me.
By using deadly force.
I used deadly force.
That you knew was going to kill.
I didn't know if it was going to kill them, but I used deadly force to stop the threat that was attacking me.
You intentionally used deadly force against Joseph Rosenbaum, correct?
Yes.
You intentionally used deadly force against the man who came and tried to kick you in the face,
Yes.
correct? You intentionally used deadly force against Anthony Huber, correct?
Yes.
You intentionally used deadly force against Gage Grosskreutz, correct?
Yes.
With regard to Joseph Rosenbaum, you fired 4 shots at him, correct?
Yes.
You intended to kill him, correct?
I didn't intend to kill him. I intended to stop the person who was attacking me and trying to steal my gun.
And it went on for hour after hour of the prosecution's attorney trying try after try, and he could never trick Kyle Rittenhouse into making this admission. I thought to myself several times throughout this exhausting attempt that this kid is making a fool out of this man. I mean, he absolutely played patty cake with the prosecution on the point of intent to kill. And there was another interesting point made in Kyle Rittenhouse's testimony that absolutely blindsided the prosecution. And here it is.
Evening around 3:34, Nick Smith called me and Dominic.
And when he called you, what was the nature of the call?
At first, Nick Smith wanted us to drive him to Chicago by O'Hare Airport, the suburbs of Chicago, because he wanted to buy a bulletproof vest. And Dominic said, okay, we'll drive him. And then he said, okay, I need you to pick me up at like 3:30, 4 o'clock.
Okay. Did you go and pick him up eventually?
Yes, we actually, before we picked him up, we went to Jelensky's.
Okay. What did you do at Jelensky's?
We bought, Dominic wanted me to buy 2 rifle slings.
And did you?
I did.
One was for what?
One was for my rifle, and the other one was for Dominic's rifle.
Okay. And why did you care about your rifles that evening?
The reason for the slings were just so it's like a retainer, so if I'm helping somebody with first aid, I can just like dangle my rifle behind me and I don't have to worry about somebody just randomly going and picking it up off the ground, just as like an extra measure so it won't be taken from the ground.
And what time did you go to Jelensky's?
I want to say about 2:30, but I don't know exactly for sure.
Okay. When did you first have contact with Nick Smith?
3:30, 3:15.
Okay.
3:15, 3:30.
And was there any discussion regarding car source at that time?
Yes.
What?
Nick Smith, once we picked him up, he wanted to go to a bank to withdraw money. The bank was closed, and then he was like, hey, would you guys like to come with me and help watch over the car source, make sure there's no fires or anything? And Dominic said yes. I agreed. I said okay. And then I said, here, Nick, I don't really need my bulletproof vest. I'm going to be helping people with first aid, so I gave him my bulletproof vest.
And by you giving him your bulletproof vest, did that stop the need to go to someplace by O'Hare Airport?
Yes.
Okay. And why does a 17-year-old kid have a bulletproof vest?
It was issued to me by the Grays Lake Police Department.
Okay. You didn't purchase it?
No, I did not.
So it's very interesting, if true, that the police issued the bulletproof vest to Kyle Rittenhouse. Apparently, he was enrolled in some law enforcement training curriculum through the college or university in his particular city that was administered in conjunction with local law enforcement agencies. And the prosecution was not ready for this testimony and tried to get the judge to allow them to bring in witnesses to refute this, but it seems that this is now in the evidence. Remember, this will be analyzed if the prosecution can overcome the self-defense assertions. But if they can reach the merits of their particular counts that they have alleged in the criminal complaint, Rittenhouse is saying No, I went there with the intent of administering first aid, and that was my primary goal. And I didn't go there with the express intent to kill or to get into any shooting match because I gave my vest, my bulletproof vest, I gave it to my friend to use in the event that the group as a whole needed to defend the members of the group. So this kind of tears down the prosecution theory that Rittenhouse went there with the express intent to kill. So now I'm going to take you inside of my notebook to show you and how I teach law students how to apply the facts to the law. So when you see this written in statute form, for the most part in most jurisdictions, this is the analysis of how the elements of the law will shake out. So I teach law students how to isolate only relevant facts and apply them to the elements of the law. So you cannot analyze facts that are not dispositive to the application of the law for each particular count. For example, as I stated before, whatever facts as it relates to self-defense, as it relates to count 4 regarding Gage Grosskreutz, those facts would not be dispositive to the analysis of self-defense as it relates to count 1 or count 3, the two counts that I'm discussing right now. And so you have to stay focused only on the facts that are dispositive to the application of the actual elements of the law as it relates to the count that you are analyzing at this particular time. And this is what the jury will be doing starting on Monday. So facts like whether Kyle Rittenhouse was old enough, or whether he lived in a particular state or city, or whether he crossed state lines with a gun, which he didn't, are all facts that are not dispositive in any way, shape, form, or fashion to the elements of any of the counts. And now, before there will be someone to clap back in the comments regarding whether or not Kyle Rittenhouse crossed state lines with a weapon, that is an untrue fact. That weapon belonged to his friend who lived in Wisconsin, and he merely borrowed his friend's gun, the gun that was purchased in Wisconsin, that was used in Wisconsin. So there is no crossing a state line with the gun. That is a disputed fact that has been refuted long before the trial ever started. That is a fact that has been refuted long before the trial ever started. But anyway, you have to go step by step, element by element. And you start with element 1, the killing of a human being. And when you get to the assessment of the applicable intent, for the most part, in most jurisdictions, this is referred to in general as malice of forethought, a very legal word. And it really just means a way of assessing an intent or a requisite culpable mental state of a person who is committing a crime. And across the various jurisdictions, you can establish malice of forethought in several ways, like intent to kill or reckless indifference. And you can see that this is how we get our counts 1 and 3. This is where this probably came from when the legislature was working on the wording of the particular law. And so in this particular jurisdiction, Wisconsin, there are 2 ways to establish the requisite culpability aspect for this particular element of the crime. But as you can see, you can't get there if the killing is excused or justified, i.e. by self-defense. So the self-defense aspect is going to be key, and there is no way around the fact that you have to conduct this analysis first. And so, for the most part, and in most jurisdictions, here are the elements of self-defense. A person may use deadly force in self-defense if 1. He is without fault in starting the altercation, and you will see the prosecution is desperate to prove that Kyle Rittenhouse threatened individuals by pointing his gun at them prior to the unfortunate killings. But just rather than pointing his gun at random people, the prosecution would need to establish that he pointed his gun at the deceased individual or pertinent to this particular count, count 1 or count 3. And so we've seen a lot of courtroom activity and discussion about that. And then element 2 is that he is confronted with unlawful force. And element 3, he is threatened with either A, death, or B, great bodily harm. And so these are the elements of self-defense. And so here is a copy of the Wisconsin pattern jury instruction for these types of homicide charges in Wisconsin. And this is what the attorneys and the judge will be using this weekend to get a finalized jury instruction ready for the jury on Monday. So as you can see, the first thing you'll see at the very beginning of the pattern jury instruction is the self-defense discussion. And when the time comes, you're going to see that the judge is going to make sure that that is reflected very early on in the jury instruction for this particular case as well. But I want to look at this because there was discussion about the fact that the prosecution was trying to introduce lesser charges today when the judge started their discussions about the jury instructions, because it requires input from both sides before the judge determines what the final jury instruction will be. When you read this, you can see that this can result in a justified killing, i.e., not guilty, but it can also result in a finding of guilt on a lesser charge of second-degree intentional homicide and maybe even some other lesser charges as well. So on Monday, the jury will see that either they can arrive at a finding that a defendant is not guilty of any homicide offense as it relates to the deceased individual that is pertinent to this particular count, if the defendant reasonably believed that he was preventing or terminating an unlawful interference with his person and reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. So in this particular case, he can be found not guilty, and that killing will be found to be justified. Or the jury can enter a finding that the defendant is guilty of second-degree intentional homicide if the defendant caused the death of the deceased individual referenced in this particular count with intent to kill and actually believe the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. So if the belief or the amount of force used is found to be unreasonable, then the jury can go ahead and find the defendant guilty of a lesser charge of second-degree intentional homicide, or maybe even some other lesser charges. And when you look at that pattern jury instruction, you'll see that there are several lesser charge options. But as you can see in the discussion about self-defense, it gives the jury a chance to ascertain if the force the defendant used was or was not necessary to terminate that threat. And if the finding is that the defendant used more force than was necessary, then the jury can find him guilty of second-degree intentional homicide or another lesser charge as referenced. So as you can see, this is really built into the self-defense deliberations, and in my opinion, this was not some last-minute proffer of lesser charges on the part of the prosecution just because they were losing the case or just because they had had some very poor performance up until this point. So if the judge does not dismiss the case with prejudice as a result of the prosecution's poor performance and as a result of a major misstep in the presence of the jury by the prosecution during its cross-examination of Rittenhouse, this case could go any way. We have no way of knowing. It could result in not guilty as a justified killing as a result of self-defense, or it could be a finding of a lesser charge, or it could be a finding of guilt on some of the original charges that were requested in the original criminal complaint. And although there are very strong facts on the issue of affirmative defense of self-defense, you have two deceased individuals, and this may result in some pressure on the jury to enter some charge on the counts as they relate to the deceased individuals. But you can never know what a jury might do. In one case, the facts reveal that one of the deceased persons kicked Kyle Rittenhouse in the head, and in another, the facts show that the person hit him in the head with a skateboard. So if this could result in death, then deadly force is warranted. If he should have used lesser or non-deadly force, then the jury can find him guilty of a lesser charge. At any rate, we'll know sometime next week. And it is possible that it could result in a hung jury as well. But tell me what you think. If you think the verdict will be guilty or not guilty, let me know down in the comments. But until then, if you've enjoyed this video, please give me a big thumbs up, and please also subscribe to my YouTube channel and click the bell so you'll be notified whenever I post new videos on this topic. And please also follow me on TikTok and Instagram.